Welcome back to another video. In this video, we're going to be introducing the concept of a license. And throughout these series of videos, we're going to talk about what sort of licenses there are and how they have changed over the years and what is meant by a license and how that is also distinct from a lease. So let's get started. Okay, so in general, there is no right for B to enter onto land in the possession of A without A's permission. So if B has permission, it is a license, but that does not make it a proprietary interest, a right in rem. So to avoid action for trespass or nuisance, B will need a license to access that land. Now, if it is not a proprietary interest, can we make it registrable in unregistered land? No, okay? So if it is not a proprietary interest, it is not registrable under the Land Charges Act. Now, we had a look, it's also not protected under the Land Registration Act either, okay? And we're going to have a look in a minute at like why they're not proprietary and how this operates in practice. If you don't understand, the discussion about the Land Charges Act and the Land Registration Act, I would highly recommend you check out my videos on registered land and unregistered land, where we discuss these concepts in depth, and also check out my introductory videos on interests in land. So, in short, you need a license to occupy property for even a very limited amount of time. Okay, and here are some examples. So, watching a film in a cinema, you have to have you have a license whenever you watch a film in a cinema to watch that film. Okay, you can only access that land where they're showing the film with a license. Okay, and that license is your cinema ticket essentially. So in Hurston Picture Theatres, they tried to evict a man, but he said no, he had a license, but they at the cinema threw him out, and eventually, this case, he won. It was held that he had a license at the time to be there, and he got compensation. So his license was his cinema ticket. So they had no right to throw him out. Running a school, you have to have a license to run a school too. So in Hampstead Gardens, there were two headmasters who tried to join schools together, and that didn't work out and they fell out. The court said one had a license to stay on the property and the other didn't. Okay. And then there's erecting advertising hoarding. And in this case, they said that there was a license to erect advertising, and if you don't have a license, you can't put up the hoarding. So they're all pretty straightforward, I think. You need to have a license to use buildings as a social club. So in Onyx and Beard, you need a license to use buildings as a social club. So any damage to that property would terminate a license. And remember, a license only gives you permission to do what a license says. So, if you've got a license and it allows you to do certain things, if you go above and beyond those measures, above and beyond those stipulations, you're going to be in breach of that license. And there's also parking cars as an example. So you need a license to park your car. And in Batchelor and Marlow, we can see this. So the right to park a car in a particular area in residential accommodation can be incredibly valuable. So it is important to know whether parking your car in a space reserved for you is a proprietary interest, because if it is, it will make your house a lot more valuable when you sell it on. Now, parking rights can be proprietary. They can only be bought or sold if a proprietary interest, for example, in the form of a lease. You can lease parking spaces, and doing this in London can actually make you a lot of money. Some people argue that should be a proprietary right, and some people think that is rubbish. Okay, but parking cars in this case was a license. Okay, I'm just going to explain a bit more about licenses, but because I don't know whether I've really drilled home what exactly they are and how they operate, but a license is given by the owner of the land, that's the licensor, to someone else, the licensee, permitting him to do something on the owner's land. And in Thomas and Sorrell in 1673 said they are personal permission to the land. So it gives A a personal right to do something on B's land, and it's not proprietary in nature, it's a personal right. And we looked at the distinction between personal and proprietary rights in an earlier video. A license is a right over the land and not an interest in land, therefore. And without the permission, without the appropriate permission, that person would be trespassing. And this differs to an easement, which grants the owner of land A the right to do something over land B. And there are no formal requirements for the creation of a license, but it may depend on fulfillment of criteria in other areas of law. For example, a contractual license will need, for example, offer and acceptance, which you should have learnt in your first year of doing law about the different requirements for a contract. A license is a right to use another's land that is either inherently capable of being proprietary rights. In other words, it does not fit within the definition of any known proprietary right, such as a right for my children to play in your garden, or one that arises because the parties deliberately or accidentally do not use a deed, for example, failed to use the proper formalities for the creation of a proprietary right, with the result that the claimant only has a license. Okay. Again, just note at this beginning stage, the only things that are very important so far that you should take in and should note is that you need a license to access someone else's land. Without that, you could be sued for nuisance or trespass. And there are some clear examples of when licenses operate, and these are shown here, such as watching a film, running a school, erecting advertising, etc. But really, we want to look at this question as to why is a license not proprietary? We've seen it's a personal right and not a proprietary right, and why is that the case? So, in Street and Mountford, Lord Templeman said that a license in connection with land, while entitling the licensee to use the land for the purposes it's authorised by the licence, does not create an estate in land. So he is saying a licence can grant use of the land, but the licence is not giving an estate. So a licence is not legal. And in the Calgarth in 1927, Scruton says, when you invite a person into your house to use the staircase, you do not invite him to slide down the banisters. So the idea being, let's suppose the person falls off the banister and has not been given the permission to do this. Can he sue for injury? The answer is probably not, because the occupier had no duty of care. So if the transaction between A and B is proprietary, for example, a lease, it would be capable of binding A's successor in title. So we can bind third parties. But if it is merely proprietary, which a license isn't, a license is not proprietary, it's only enforceable between A and B themselves. Okay, a straightforward contract so can only bind the parties themselves with limited exceptions. So, and we're going to look at this distinction between licenses and leases in the next video. So make sure you watch that one. But note that a lease, as it's proprietary, can bind successors entitled to the land, whereas a license cannot. A license is only enforceable between the parties to that license themselves. Now, the lease-license distinction also affects how a landlord licensor recovers possession of his property, the protection of business tenants, and duties of landlords and licensors to repair property. Generally speaking, only a leaseholder can sue in tort for nuisance and trespass to land, although in limited circumstances, a license may give rise to a remedy. So the distinction is necessary in terms of the fact you can only make claims in respects of torts or land if you are a leaseholder and not if you are a license holder. However, this does appear to have been relaxed a little. Just have a look at the Manchester Airport and Dutton case, 2000, for example, where we had trespassers of land, trespassers to the Manchester Airport, and we had contractors doing up the land, and yet they were allowed, the contractors were able to remove these protesters from the land, okay, despite only having a license to do their work. Also, the distinction can affect the right to claim damages for negligence if the duty relied upon by the claimant depends on whether the claimant is a tenant or a licensee. And that was seen in the APA case, so in 1964. And in this case, a woman claimed damage in negligence against the owner of the house in which she had a room. Her belongings were stolen from her room because the door lock was broken. If she had been a tenant, for example, there had been a lease, then the landlord would have been under no duty to take a reasonable care of her belongings, as she would have been had exclusive possession of her room. The lock would have been her responsibility, essentially. But as she was a licensee and not a leaseholder, the landlord owed her a duty of care to mend the lock and therefore had to pay her damages. Okay, but really, you could ask yourself the question: why should it make a difference whether she is a licensee or a leaseholder in respect to the duty of care of the defendant, of the landlord? Questions to ask yourself and have a think about. But note, licenses cover a very wide range of factual circumstances. At one end of the scale, a license is the reason the milkman does not commit trespass when he leaves a pint of milk outside A's door, nor does B commit trespass when he pays to go into A's cinema. At the end of the scale, a license may be a lease substitute, giving B the right to occupy A's property, or an easement substitute, giving A the right to use a footpath over A's land. Now, this matters because so many interests over other people's property arise simply by use, like walking over the same piece of land, driving your tractor over the same piece of field, walking up and down the same private road without disturbance, etc. So a license is personal and a lease is proprietary. While the courts have no problem in holding that the first two examples do not bind A's successor in title, they have struggled with what happens when the successor in title has notice of B's agreement with A, but still seeks to take the land free of it. So if A and B have a license, but C, the subsequent purchaser of B's property, has notice of A and B's license, is he bound by the license, or should he take free of it? And I think we're going to dive into a lot more depth between these sorts of circumstances and all these different questions in the next video when we talk about lease and licenses and how they differ and how the court have construed the differences. But just to finish off this sort of introductory video, I'm just going to talk about very briefly the different types of licenses. So we got the bare license, which is probably the most common type of license, and it gives permission to enter upon the land given voluntarily by the owner, who receives nothing in return. So there is a contract here. Sorry, there is no contract here. So there is no need for consideration, and there's no required form of creation either. You know, it could be expressed, it could be implied, it could be oral, it could be written, and it can also be terminated at any point. So it's a very, very simple, basic license. And for example, it could be, you can have a bare license whenever you invite someone into your house. That's a license to come into the property. But if you told them to leave, then they'd have to leave. That's the sort of thing. It's very simple. Happens every day. You probably hand out bare licenses yourself occasionally. Having a house party, come in, 10 people, 20 people or more. That's a bare license you're offering to people. And then as soon as you want the party to end, you can terminate that bare license. Then there's licenses coupled with an interest or grant. So, for example, a profit à prendre will have to have a license attached or coupled to the profit in order for that profit to be exercised. Okay, but arguably it's not really a license, as it's simply just allowing the proprietary right to be exercised. So, for example, allowing someone to come on your land to chop wood and take wood away. But arguably, because it's coupled with an interest, it's just allowing the proprietary right to be exercised anyway. So yeah, you could argue that it's not really even a license. And then there's the contractual license, which is given return for actual consideration. So that would be the cinema ticket, for example. You pay for your cinema ticket and then you're allowed to go watch the film. And that is governed by the normal rules of contract. So that probably wraps up this video. I hope I made sense. I think there are some areas where it could have been a little bit confusing, but I think the problem with that lies in the fact that we are sort of dealing with something which is not proprietary and not clearly defined as a thing. So, what exactly is a license? Well, it's not a lease, and it operates in certain situations, but it's not always exactly clear exactly how it works and how it arises and why it operates in certain ways. And that may be one of the reasons why it could have been a little bit difficult for maybe me to explain and for you to understand. So if you do have any particular questions or queries about this video, then please leave a comment below and I will get back to you about anything and everything that you have to ask about this. And make sure you subscribe, because we're going to be talking about the distinction between leases and licenses in the next video. Thank you very much for watching.